story. We're now moving on and getting you some more news, and this is about that big debate happening at the Supreme Court of India. The hearing pertained to the constitutional validity, or more importantly, whether it's an essential religious practice. The hijab hearing in the Supreme Court has concluded for the day. It will resume once again tomorrow, but today's hearing was indeed an eventful one. We had some big arguments being made by the Solicitor General of India, one of the top law officers of the government. Mr. Tushar Mehta cited the ongoing anti-hijab protests in Iran, saying that there are Islamic countries where constitutionally women are fighting against the imposition of hijab. So wearing a headscarf is not an essential religious practice in Islam. That's at the heart of the debate. Tushar Mehta further said that a mere mention in Holy Quran will not make hijab essential. Wearing a hijab may be permissible or an ideal practice, but that doesn't make it mandatory. This comes even as the centre went on record to point fingers at the PFI for starting agitation to get people across the country to wear hijab. Our legal correspondent Ananya Bhatnagar is joining us on the broadcast. Ananya, why don't you sum up the arguments for the day for our viewers? What exactly transpired? What were the other arguments that Mr. Tushar Mehta made? And from the other side, the arguments of Mr. Dushyant Dave, if he argued today.
Well, yes, definitely a long hearing since, in fact, 10:45 till, in fact, 4:30 it continued. The matter continued around 4 p.m. And, in fact, lengthy submissions were made both on the side of the Karnataka government and senior advocate Dushyant Dave, who actually made a very important argument before the court that he said that hijab can be equated with, in fact, the women wearing headgear on, in fact, covering their head in the Hindu religion when they visit temples or otherwise. So clearly drawing a distinction between women covering their head in the Hindu religion and the wearing of a hijab, and said that it is a sign of dignity. However, the court said that the definition of dignity changes from time to time. And in fact, then Mr. Tushar Mehta began his submission, first going on the role of the Popular Front of India, saying that all of these protests, the agitations that were there in the Karnataka Hijab row were actually premeditated, pre-engineered by the Popular Front of India's student wing, that is the Campus Front of India, CFI. And he went on to explain the timeline of those events. And then he came on another aspect that hijab is not an essential religious practice in the Islamic religion. And in fact, in Islam, the countries which are governed by Islamic principles, like in Iran, which are constitutionally Islamic in nature, there also women are protesting against the hijab and to basically against the hijab, and said that that clearly means that hijab might be mentioned in the Quranic in scriptures, but then it is not an essential religious practice. So this was the line of argument that was adopted by Solicitor General Tushar Mehta. In fact, he also went on to draw a distinction between the Shirur Much and the Dargah Committee case, clearly saying that the view adopted in the Shirur Much case was basically of a 7-judges bench, and so that there is no conflict in the Dargah Committee case. It was said that the view is right, though it is from a 7-judges bench, and it is there just in case.
At the heart of this entire debate, as Ananya is pointing out, is the question of merit, whether covering your head, wearing a hijab, is an essential religious practice protected under Article 25, the fundamental right under Part 3 of the Indian Constitution. If it is, the court will protect it despite the institutional norms. And if it's not, the court will give preference to the institutional norms like a school uniform. We'll talk about that story and much more on the other side of a quick